In Part 2, we dealt with the criminal penalties and sanctions on driver's licenses, and now we're going to talk about administrative license suspension and revocation penalties. These laws were enacted by Congress later after the criminal penalties were put in place. The concept here is that the state has the right to civilly take away your right to drive administratively even before you have the criminal case. And in almost all states, these administrative penalties will be enforced even if you win or have your DUI case dismissed. So these administrative penalties, which sound like double jeopardy, have been ruled by the U.S. Supreme Court to be a civil matter that does not prevent additional sanctions from coming under the criminal case. As most laws are written today, this type of penalty applies to first offenders, second offenders, and other repeat drunk driving or drugged driving offenders. There are two situations where this applies. That is, if you agreed to take the test after you were arrested for DUI and you were over the legal limit. For people who are 21 and over, that's a .08, but for young people it can be a 0 tolerance or even a very low reading like a .02. There are also administrative suspensions for a second type of DUI driver, and that's the ones who refuse the official forensic breath test, laboratory blood test, or quantitative urine test. Once again, federal highway money is withheld from states that don't enact this type of law to punish the people ahead of the criminal trial, regardless of the criminal trial in most states like California. In numerous states, believe it or not, a DUI suspect can refuse the breath test offered by police and be written up as a refusal. In many states like Georgia, that's 1 year without any type of license if you lose that hearing. Then the same implied consent laws permit the officer to obtain a warrant from a judge to collect a forcible blood draw or a urine catheterization from that same person. In such instances, you not only might be suspended for refusing, but you then might have to face a high blood alcohol level test from the forcible blood draw in your trial. Today, the national lobbying effort by MAD is to force every convicted drunk driver to install alcohol interlock devices to prevent recidivism of intoxicated drivers. The MAD activists have even encouraged a few state legislators to offer some form of diversion or expunction, that is record restriction, for DUI offenders, but to mandate an expensive and embarrassing interlock device on your car for the full length of your probation. That could be 1 year, or in other states it could be even longer. This change in the law and what's going on with the increasing punishments that are being added to DUI convictions is why Team DUI was set up. We're going to go to Part 4 next and complete this series.